Okay, good afternoon, doctors. I just need a quick sound check. If any one of my staff or any of the doctors out there would actually just let me know that you can hear me okay, you can hear us okay. Got a fantastic program that we're putting on today. And I just need to have anyone, okay, great. Yes, we can hear you. Fantastic. Okay. As many of you know, or some of you don't know that are new to Spinal Kinetics, at Spinal Kinetics, we do webinars 2 times a month, and we bring in relevant speakers on relevant topics, and I'm really, really glad to have Keith Pendleton with us here today. He's going to go over the laws of medical necessity. There couldn't be a more pertinent topic in personal injury. There also is not an attorney in the market in the country that does not understand these laws, these rules of actually the rules of getting paid in personal injury. And they combine right in with anytime that you want to get paid, you have to have supportive documentation that shows the level of injury that you have to support the care that you have. So diagnosis drives the whole payment process, but then you have to have somebody who can teach you the laws of medical necessity. And so that's what the program is going to be about today. What I want to first do, my name is Dr. Cronk, for those of you that don't know me or aren't familiar with me. I'm the Director of Education for Spinal Kinetics. And Spinal Kinetics is a nationwide service, and I'm very proud of the service that Spinal Kinetics does, because we're on the forefront of changing the environment in the ligament injury arena. We are the ones, I think we're the spearhead of a group that says, look, the science of these injuries make them super significant. The providers that actually treat these, in my experience, are some of the most important providers in the country. Okay, because these conditions are the #1 cause of chronic pain and of chronic expense to the patient. So doctors have to get to, or patients have to get to doctors that understand this condition. Computerized radiographic mensuration analysis is the registered trademark of Spinal Kinetics. That's our patented, or not our patented, our process. That's the name of our process in our system, and the various things that we build behind the system to ensure accuracy within our system. So what we do is we help doctors to understand how much excessive motion at which levels in the spine there are. Now, of course, that is the #1 cause. It's called a spinal instability. It's the #1 cause of everything that you see listed there: low back pain, headaches, neck pain, pain going down the arms, pain going down the legs. You can get into the upper cervical area, and then you start to get into concentration problems, concussion syndromes that won't abate. So every single symptom that you see there, there's consensus that says this is what causes it. Diagnosis is getting to the cause, looking at the symptoms, and getting to the cause of the problem. So what we at Spinal Kinetics help doctors of all kinds, medical doctors, chiropractors, and osteopathic doctors, anyone that treats the spine, we help the doctor get to the cause of the condition. And not just so that they're looking or treating or diagnosing the symptoms of the condition, but they're actually getting to the cause of it. It's very easy. Injuries cause compressive and shear forces into the spine. There's 3 types of injury derangement patterns. There's fractures, there's excessive motion, which is the worst condition a patient can have. And then the other ligament condition that a patient can have is a disc condition. So any doctor can take an injury patient in, say, injury patient says, look, I have neck pain, it's level 8, headaches, that's a level 8. You do an evaluation. And what we work with in Spinal Kinetics is we're increasing the professionalism of the doctors that treat these conditions. So any doctor can start to pain map out the pain condition. They can do a simple examination that every doctor is supposed to be doing, which is a motor and sensory examination. You start looking at the levels. Those levels lead the doctor right to specific levels in the spine that they should be evaluating with imaging. Lo and behold, they do their stress testing. They send out to Spinal Kinetics. That's the report. Now we actually have grade 3 sprains here, grade 2 sprains here, consistent with the levels. And now consistent with why the patient would have headaches, consistent with why the patient would have neck pain, and this occurs with the neck or the lower back. Now, If a patient has a disc herniation or their thoughts of a disc herniation, fine, you add that to the exam, and now you also find that you have excessive motion at the level of and above the worst soft tissue injuries that a patient can have. But what's worse for the patient is when they have a doctor who's treating them that does not know that these injuries even exist. And that's the whole purpose of spinal kinetics. Now, as a company, we want to actually reduce down the epidemic of chronic pain, and it starts with better diagnostics. We are very much so in the injury market, so I bring injury experts in at times to help providers in the injury market. And that's why Keith and I have worked together a lot in the past. The reason why I work with Keith is because I fully support and I fully understand what he does. There's not a provider that shouldn't be involved with Keith on the payment side of things. So today we have a program called the Laws of Medical Necessity, and medical necessity comes up with your denials. It comes up with a lot of different things. And that's why I'm very happy to have Keith Pendleton. Keith, I'm gonna basically switch over the program to you at this point. So you're gonna see that pop up on your screen. If you just hit the OK, then we'll see, now we actually see your slides. So Keith, you can take it away from here. I'm really, really happy to have you on the program today.
Well, thanks for having me too. Dr. Cronk, can you hear me okay?
Yeah, I can hear you just fine, Keith.
Okay, so folks, we have a lot of really cool information we're going to go over today. And Dr. Cronk, I also want you to please feel free as we go through it to jump in with questions and what have you. And folks, I did a very comprehensive version of a presentation surrounding these themes that was recorded that you can get on the website of pibackoffice.com. It's right there. So what I'm getting at is that if there are a lot of questions that are generated as a result of this interview, this back and forth between Dr. Cronk and I, please understand that you can go and listen to a very comprehensive 45-minute presentation which goes over a very powerful sample release letter that you can be using in your PI cases. That's also available at that site for free. It's in the freebie section. So please just we're going to kick back. This is going to be a kind of an introductory session. And Dr. Cronk, I'm going to welcome you. If Spinal Kinetics wants to have a series on the laws of medical necessity, I would be definitely in favor of doing something like that, but more on that later. Folks, I hear this, I wish I had a dime for every provider that tells me, Keith, I do all this documentation and I still have trouble getting paid. I still run into trouble. And when I ask them, it's amazing how many times it comes back to the issue of, oh, care is not medically necessary. Now, it arises in so many different ways. In some states, you have these no-fault payers, and the way it rises there is where they suddenly suspend benefits and stop paying. Well, I know of chiropractors who, when the no-fault payer suspends benefits and stops paying and says, we're doing a review, and maybe they haven't even done the review yet, I know of doctors that just stop treating the patient and they're done. And it's when you understand the laws of medical necessity and how easy it is to get paid for care even beyond a time that a no-fault payer just even breathes the words, we're doing a review. If you knew how easy it was, once you know the laws, then you might continue treating the patient, of course, provided that you are of the opinion that the care is medically necessary. Okay, and so we're going to be talking about these laws, or at least start that process today. But it comes up lots of other ways too. So I just mentioned the no-fault payer. Well, then you also have the fault-based payers like liability, uninsured, and underinsured. And I find that chiropractors in the fault-based states, 80% of the states in the country are fault-based states. When dealing directly with those fault-based payers, like the liability insurance. That's the insurance of the person who caused the accident. Hey, Keith, we get adjusters contacting our patients, scaring them away from care, doing these, saying that they reviewed our care and it's not medically necessary, and wanting to lowball us because, let's say, it was a low-impact case. Then, of course, you have the attorneys. You have cases where you're dealing with attorneys you know, some attorneys you know, trust, other attorneys you don't know, don't trust, maybe some of them have messed with you in the past, maybe some attorneys that don't even believe in, a lot of you, I'm assuming, are chiropractors. You have attorneys that don't subscribe to chiropractic and will never refer, or very rarely refer to a chiropractor. You have a whole brand of attorneys like that. You have a group of attorneys, sometimes on the street they're referred to as the burn and churn attorneys, that I've seen cases where attorneys question all the time the medical necessity of the care of the providers. In fact, I've seen instances where the attorneys tell the adjuster the care is all medically necessary, they get all the care paid for, and then they turn around and tell the doctor, well, the care, the adjuster did a review and they said none of your care was medically necessary. So I've seen this situation of care not medically necessary arise, and it arises in so many different contexts, and I want you to realize how broad this denial pattern is. But you know, when I step back and I look at the whole situation, it reminds me so much of baseball. Okay, and what I see is providers out there showing up day after day after day to the game or to practice, and they've got their glove, they've got their hat, they've got their ball, right, and they've got the various equipment that you would think would make for a good baseball player, and they simply don't even know the rules of baseball. And when you look at that sport and how intricate it is with the different rules and everything, the rules of stealing and everything, okay, to show up to practice day after day after day and never learn the rules, well, you're going to be on the bench, and you're going to continue being on the bench. And I have doctors that are so used to being on the bench when it comes to payment time that they actually think that that is the way to do business. I'm going to keep sitting on the bench. I'm going to keep accepting 60 to 70% reductions of my claims, because that's just business. That's just the way it is. Okay, well then keep showing up to practice in the games and keep sitting on the bench. Okay, or start learning the rules. And I can assure you that personal injury is just as intricate as the sport of baseball. So it's time to start learning those rules. And there are some very, very powerful rules that once you learn them have immediate, a dramatic impact on your ability to get paid. And it's not like you're being a money-grubbing healthcare provider. You're simply getting paid for services that you believe are reasonably necessary. Why not? So the patient gets the care they want and you're getting paid. Okay, and it's almost unfathomable to me that this issue continues. And I'll give you a quick story here. So I had a chiropractor in the state of Washington, and Washington, as some of you may know, is a hybrid state. $10,000 of no-fault benefits is required as a matter of law unless the insured waives it. So oftentimes patients do in fact have no-fault benefits available up to about $10,000 by default. And this one chiropractor was having trouble with a particular payer, no-fault payer, just routinely sending his claims off for an independent medical exam. Okay, and so he started following the rules for crushing it in PI that I teach. I teach 3 basic steps to crushing it in PI. One of which is learning how to communicate the laws of medical necessity in your communications, particularly in your written communications. So he began to follow those 3 steps, and over a period of 18 months, even though he regularly treats patients without insurance and has continued to, over 18 months, he had 3 reviews only. A very small percentage of his total number of cases. 3 reviews. In other words, the number of reviews dropped like a rock. And so I said, well, that's awesome. What happened in those 3 cases? Well, Keith, I did the things the way you taught me. I sent in my legal packets. I sent in my medical packets. I released the patient from care the way you teach. And so I decided I'm going to write an appeal letter. And I used the template that you provided. And in all 3 cases, the adjusters exercised discretion, lifted the suspension, and started paying again. Okay, so now over the last 6 months, this was kind of the final part of the story. Over the last 6 months, I have not been reviewed once by this payer. So here's a doctor that has not just reduced, this provider has eliminated with one of the toughest payers in the state of Washington that he's having to deal with. And I know for a fact, I talk with a lot of providers who are dealing with that payer. He's eliminated reviews. Now it could come back again. These things tend to come in phases or what have you. But folks, why not spend a little time learning the art and science of the laws of medical necessity, building it into your protocol, and more successfully getting paid and not wasting so much time spinning your wheels and feeling the angst, or just simply saying, you know, I'm going to keep sitting on the bench because that's, I guess, the way things are. I'm going to keep sitting on that bench, right? And I can tell you right now that these laws are largely unknown. Knowing them, my knowledge about these laws comes from hundreds and hundreds and hundreds of hours of legal research that I did in every state across the country in various bodies of law, and it takes time to produce a diamond. It takes time for a diamond to be produced. It takes pressure and time to produce a diamond, and that's what effectively happened. Was over that period of time was I crunched down the laws of medical necessity into some very simple propositions that have been very effective at helping doctors with this whole issue. Okay, so with that, let me share just a little bit more detail. And again, I want to remind, hey, Dr. Cronk, feel free to please jump in if you would like.
Yeah,
And,
Keith, let me first of all, I love the analogy, and for the doctors out there, I think it would be remiss not for me to speak. Look, doctors, I was in private practice for 17 years. I know what the life of a private practitioner is, and you can't know everything, right? Now, just like Keith said, you are in a baseball game, and the game has rules, right? But every great baseball player has one other thing, or a number of things that they have in their development always, and that's a coach. And that's a coach who studies the rules, right? So you don't necessarily have to know how, you don't need to know, hey, these ones are old, these ones aren't being used anymore, this is a new rule change. No baseball player actually goes, oh, well, I'm going to be on the field, I'm going to be a professional, I'm going to be a top paid baseball player. When rule changes occur, the baseball player doesn't study the rules and everything else. A coach does that. And somebody who actually, really streamlines it down. And so, one of the things that in working with you, Keith, is that we've always just relied, and I know the role of this, we've relied on the fact that you make this very, very simple. And I know from the process point of view, it can sound complicated, but because of the forms that you've actually made, and you keep, when you say, hey, pressure and time creates diamonds, we at Spinal Kinetics, and the doctors that I've been involved with that are involved with you know that those diamonds, one of the things I want to do is when I'm in a personal injury case or I'm in an insurance case or whatever, all of my foundational documentation is key. So I have to start out of the gate correct. Would you say that's fair to say, Keith?
Totally.
Yeah. So, what I like about what you're saying is I already know that you've produced all this stuff. You produced all these forms, and so everything's now automated. I mean, if I'm in private practice, I want that process automated, because that's where, at the end of the day, I mean, I'm all about documentation. You know that, Keith, and documentation is what supports benefits. You can't get benefits without documentation, but you also have the other side of the benefit side where your financial benefit documentation needs to be there as well. And that's what you're talking, that's really what you're talking about. I think it's fantastic. I mean, like I said, if you're sitting there, and I love the analogy of the fact that you're not in the game, right? You're just, you're just sitting there on the bench, and if you want to still be on the bench, my thing is, and I think Keith, you would agree to it, is if you're gonna be the bench player, and that's fine. There is a role for the guy that's just on the bench, but don't complain about it. Do you know what I mean? If you're sitting here going, oh wow, I don't get paid, or my attorneys are cutting my bills by 50%, which we hear all the time, right? And you're sitting there going, well, okay, gosh, you can either sit there and be a victim, or you can get some information and some education that provides you with action steps that makes you cause over your own environment.
Right.
And I think that to me is the way to be, and it's fantastic. I didn't mean to interrupt you. I just wanted to throw that in.
No, and folks, you mentioned Dr. Cronk mentioned about the tools and the boilerplates and all that good stuff. We're going to look at a sample here. And
yeah, but the thing I want you to say, Keith, is I want you to, and I know it may be hard for you to say this even, but once you understand it, this is easy. It's not hard. It's easy. So once a baseball player understands the new rule change, he's familiar with the whole game anyway. So it's very easy to make little tiny changes now based on the rule that make him from a good baseball player to a great baseball player.
You got it.
Because he's within the rules. So I know you will have a hard time stressing, hey, how easy you've made this, but you've made it very easy. Go ahead.
Well, and a lot of that goes back, and folks, just let me take 60 seconds and share with you the fact that PI has changed dramatically in the last 20 to 30 years. Dramatically. There have been a string of legal changes that you haven't been aware of, as well as there's been the fleshing out of laws that have been there that we haven't known about. And this has occurred over at least the last 20 years, okay, starting at around 1995. And the upshot of these changes in the laws relating to personal injury is that effectively now they empower the healthcare provider relative to automobile insurance. What I'm getting at is it is possible for you now to run a very diversified personal injury practice where maybe a portion of your cases entail attorneys, and maybe a big portion of your cases entail unrepresented cases, cases where the patient doesn't get an attorney. And I like to think of PI breaking down into 3 buckets, where you have your trusted attorneys, you have your unrepresented cases on the other end of the spectrum, and then you have the cases in the middle where you have an untrusted attorney or attorney who has messed with you in the past or what have you. And what I can share with you is that the laws that have evolved and have surfaced make it extraordinarily easy for a healthcare provider in a PI situation to treat unrepresented patients and get paid far more successfully and far more quickly than when a patient has an attorney. And they also help the provider who's tired of being pushed around by the untrusted attorneys. Okay, now if you have a good trusted relationship with an attorney and you want to keep doing things as you presently are, that's one thing. But who here hasn't dealt with the attorneys that don't believe in chiropractic, for those of you who are chiropractors, or will never refer to a chiropractor, or play those games of saying, hey, the payer said it's not medically necessary, when that never actually even happened, okay? Who wouldn't want to shape up those cases and massage that and do a better job in that and remove the angst and the hassles involved, or get paid in unrepresented cases where typically doctors are getting paid in full and faster than when the patient has an attorney. So there's been this evolution of law starting in around 1995 through the present, with a lot of the changes occurring in the first decade of the new millennium. okay, the 2001 to 2010. And Dr. Cronk, just real quickly, when did you get involved personally, individually, with the process of CRMA? What was the year of that?
1996 as a provider, so I sent out all my studies to a group called Spinalogic Diagnostics starting around 1995 or 1996, right in that area,
Yep.
up until 2004. When I left private practice in 2005, I started my own company, and that's when I started delivering the services nationally.
Right, right. Look where we're at, right smack in the middle of where so much of the development occurred. Now, folks, real quick, I get asked all the time, should I do CRMAs in my cases? And for me, it's like someone asking, should I go to baseball practice today without my glove? That's how it comes across. I mean, when you understand the role of CRMA and how it maps in the overall reimbursement process, or even just medical documentation process for that matter, it's to me, it's like showing up to, not doing it is like showing up to practice and games as a baseball player without your glove. Okay, so, but we're focusing on a law. I mean, there's lots of laws of medical necessity. Oh, by the way, some of you have heard me and heard in the industry about the Uniform Commercial Code. The Uniform Commercial Code lien law is one of the most powerful laws of medical necessity that exist. And why? Because one of the big reasons adjusters keep maybe throwing your appeals or you contesting your appeals or requests for reconsideration, one of the reasons why they keep getting thrown in the trash, quote unquote, is because the adjuster is of the opinion, or the attorney behind the scenes, without you knowing this, is of the opinion that they aren't accountable to you. So the law of the Uniform Commercial Code lien is one of the essential laws for helping to establish accountability so that you can be listened to, so that you can ask to be listened to and expect that. And that's been a big missing piece of the pie for a lot of providers. You might have the best documentation in the world. You may do a great job communicating why your care is medically necessary. And ultimately, the payer is of the opinion, well, that's great. I'm kind of tired of talking with you now. And maybe we'll just send the check to the patient and you can deal with the patient. So that's got to be brought into the picture as well. The focus today, the law that I want to focus on, is what I'll call the cure or relief standard. And this is what I refer to as the governing standard of medical necessity for reimbursement purposes in accident cases. So even if your care is doing something beyond just curing or relieving the compensable injury, doesn't mean it's not medically necessary. It just means it's not medically necessary for reimbursement purposes. So these are the words I want you to burn into your mind: the cure or relieve standard. And I want to, rather than explaining it anymore right now, what I'm going to do in a moment is come back to the sample PI release letter that we've developed that's having such a significant impact. And let's actually look at it in full bloom, okay? But this is an example of one of the laws that surfaced during this time frame. And I can tell you how. I mean, anybody who wants to know, I can tell you all about it, where it came from and what have you. But this is the governing standard of medical necessity for reimbursement purposes in accident cases. And it's also, I can tell you right now, is the number one way that reviews done of your care are openly and fundamentally defective is when the reviewer fails to cite or address the standard of medical necessity for reimbursement purposes. When the reviewer fails to cite or address the light in which they have to adjudge the care, the review is openly and fundamentally defective. And when you're able to bring that to the attention of the adjuster, both before and after the review, most adjusters, we find, exercise discretion and push aside the review. Okay, so I'm going to come back to that. But the upshot.
Keith, I want to ask you a question. I want to interrupt and ask you a question.
Yep.
Okay, I already know the answer to the question, but I want to make sure the doctors understand the answer to this question. you and I have looked at too many reviews. Okay, what percentage of reviews don't act, it just would not meet the qualifications of the standard of review that you just said?
99%.
Correct. Okay, so 99% of them are defective.
I've seen cases where when providers start asserting themselves just a little bit in this arena, I've seen cases where reviewers who catch on to this actually start citing to the standard of medical necessity for reimbursement purposes in accident cases. And they say, here are the facts, here's the standard, here's why under the standard the care is not medically necessary, therefore I conclude it's not medically necessary. As far as I'm concerned, when it comes to that factor, that element, that's a good review. Now, the review may be fundamentally defective in other ways, but with respect.
But you're saying 1%, 1%. I mean, that's not the standard of reviews that occurs.
It's probably more accurate to say 99.999%.
Correct.
Don't mention. Okay, so folks, this is the upshot. I want you to understand the ramifications of this slide, the history. Just this one law of medical necessity is the fact that we are seeing the evolution of a much more diversified approach to PI. I have providers that when they talk with me about PI and how they're doing PI, it's attorney, 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 attorney. I had one provider say, hey, Keith, the problem with CRMAs, if I may, Dr. Cronk, the problem with CRMAs is the adjusters don't like them. Oh, okay, so how do you know that the adjuster doesn't like them? Because that's what they say. Who's they? Well, the attorneys. So you haven't actually spoken with the adjusters about this, is that right? Well, that's right, but that's what the attorney told me. Well, has the attorney talked really with the adjuster about this? Or is the attorney just telling you that's what the adjusters are saying? Well, he goes, I don't know. And I said, have you ever dealt with unrepresented cases before? And he goes, no, we don't do that because they pay the patient directly. Well, if I can get you paid directly, and you could take on unrepresented cases, what I can share with you is what other doctors have told me, is that when they do the CRMA and they have everything submitted and the CRMAs get submitted, when they submit this, what I am being told is that the adjusters, for the most part, aren't squabbling about the CRMAs. You're kidding me. No. So it's really important, folks, that when you're told something through the grapevine, realize it may be suffering from a little bit of nothing more, a little bit of whisper down the lane. Or
right.
it may
it's funny that you say that, Keith, because we get on the phone with the attorneys, and I've done this plenty of times. And that same attorney that'll say, hey, look, we don't like, the adjuster said, hey, we don't like CRMA. I'm like, well, what the attorney is saying at that point is that we don't like the doctor documenting the severity and location of one of the most complicated situations that there are in the human spine. And we don't like that being highly objective, and we don't like it being comprehensive.
Right.
Right, which is insane. But what they'll also say in the same conversation is they don't like the referring chiropractor.
And all of that could be true.
And we'll even ask, I've had staff on where we ask, well, have you communicated that to your referring doctor, the person that referred you, the client?
Right.
Go ahead.
So, folks, the moral of the story here is there is a way you can approach PI in today's day and age, and this is really the prevailing business model where you're going to be most successful, is where you begin liberating yourself a bit from the predominating the historic attorney model. You learn how to deal with the unrepresented case, if for nothing else, because the mysteries of PI begin to unveil themselves in ways that they never did before. Okay, and you're going to begin to realize that there's a whole new way to do personal injury. Now, folks, again, we're going to look briefly at the sample release letter that is available on pibackoffice.com, which is based on hundreds and hundreds of hours of legal research over 15 years in multiple bodies of law. It's a diamond crunch down. It's a lot of law into a diamond, and we've had attorneys respond to that letter telling the doctor, this is the best medical packet I've ever seen in 30 years. And all we're doing is addressing where the attorney also lives. Many of these attorneys live is, yeah, I would love to have assistance in demonstrating why the chiropractic care is medically necessary. I've had doctors who start using that release letter and they just start getting referrals from attorneys. And this doctor here tells me the story one day of where an attorney calls up and sets an appointment with him because he was injured in an automobile accident. And the attorney tells us, and the doctor takes him back to the exam room and says, so tell me, what brings you here? And he says, let me tell you something. I've been seeing your medical packets for the last year, and they are the best medical packets I've ever seen in the industry, bar none. And when I got into an accident, I figured I should just come in and see you. Well, this doctor calls me up. Well, it's about 2 weeks ago, 2 or 3 weeks ago, and tells me this story. And as a disclaimer here, folks, I do not advocate doing great documentation as a way to increase settlement value. That's what happened to have here, was it happened to increase the settlement by 5 times. I think the way the AMA puts it in the 6th edition is the best way to be thinking about this, that the purpose of good documentation, this is a paraphrasing, the purpose of good documentation is to enable the adjudicators to make more accurate assessments of financial obligation. Now that's a neutral statement because it can cut either way. Okay, the purpose of good documentation is not to drive up the settlement. The purpose is for making a more accurate assessment of financial obligation. That's a major purpose, not the only. Okay, another is just simply doing a fantastic job of sizing up and assessing the patient's condition and then mapping it to a really effective course of care. Let's not forget that one. Well, this story here, look at this story. So today, he writes, I learned something about PI that will forever change how I approach injury care. I had a patient whose attorney had originally told the patient he didn't think the case would settle for much. I documented the case the way Keith Pendleton showed me how. That's, you know, the legal document, medical documentation, release from care, the 3 rules for crushing PI. Documenting the way he teaches is not difficult to do, I agree. My documentation included an impairment rating as the patient had a rateable condition. My total charges were approximately $6,000. By the way, there was no other medicals in this case. When it came time to release the patient from care, I assembled my medical packet the way, now this was communication, I assembled my medical packet the way Keith taught me how to do it and sent it off to the attorney with a cover letter. There are things I'm not sharing with you in this story, but what I will share with you is what, I mean, there was some kind of negative things that I'm just going to leave out of this, negative not for this doctor, but for the attorney and the attorney's response to this. Anyhow, he goes on to say, I tried to contact the attorney on at least 8 to 10 occasions following up to follow up, but never heard back from the attorney, which of course made me nervous. Now, he had no letter of protection here, guys. He had no letter of protection, and this is an attorney he doesn't know at all, and he's trying to contact the attorney, not getting any kind of response. So it's not like this is one of the trusted attorneys that he's worked with. How many of you have run into this? So he made the decision. This is his testimony. I made the decision to go ahead and notify the third-party liability payer of my assignment in UCC lien, a copy of which I'd filed in the state. Immediately, I received a call from the adjuster telling me as soon as he received my communication, he called the attorney and they were able to come to an immediate settlement for $30,000. There were no other medicals involved in the case. As I still have not heard from the attorney, I've asked the adjuster if they're going to protect my bills. Yes, they say. And so now the attorney, who's not been responsive, has been unwilling to give him a letter of protection. The doctor took things into his own hands, protected his bills at the adjuster level, and next thing you know, the settlement's going to the attorney, and with 2 checks, where 2 checks are being written to the attorney, one for the amount of the provider's bills and with the attorney's name and the doctor's name, and a check for the remaining portion with just the attorney and the patient's name on it. Okay, so that's what I'm talking about, a holistic approach to this, to the rules of medical necessity here. Okay, and when I say the doctor said he documented the way he taught and sent off the packet, he used this very type of letter when he sent it to the attorney, which the attorney, of course, shared with the adjuster. Now, the free letter that we're referring to, and I'm actually going to go to it right now. So if you come into PI back office, okay, www.pibackoffice.com, cool stuff. We have seminars that we're doing. We have a seminar coming up here this next weekend, October 14th in Albuquerque. We have one in Chicago in November 11th. We have one in Connecticut coming up on the 28th of October. Well, right below that is a freebie section, okay? So we're going to go there. And you'll see download the sample PI release letter. And here's this video. Get it while it's there, because this video goes into comprehensively much more detail than we can go into right now about this sample letter. So you come down here and you see a well-structured letter, and yes, I recommend you send it by certified mail. That's how important I think some of the key medical documents you have are, is let's prove that the adjuster received it, because folks, one of the things that unfortunately happens here, unfortunately, in the claims processing world, is that not necessarily all your documentation is being shared with the reviewer. Okay, and so one of the ways for helping to assure that all of the documentation is shared with the reviewer is to have proof of what you actually sent. Okay, we hear a lot about Colossus and, you know, drivers and that sort of thing, and this letter is fairly light when it comes to the what I call significant healthcare factors. I don't call them drivers. I refer to these as significant healthcare factors, is to remind the adjuster that, look, I did a good job diagnosing up the case. Please enter all the diagnostic codes into your computer adjusting system. Sometimes, folks, it's really that simple. If you don't ask, you don't get sometimes. So ask. Okay, why not? There's no harm in asking. And the nice thing about it is it keeps it front and center in your mind that when an adjuster calls and tries to lowball you, that you ask them, did you enter all the diagnostic codes into your computer adjusting system? I have 10 of them. Okay, but where we're really focusing on this letter is some of the laws of medical necessity. Okay, and one of them here shows focuses in on the issue of functional improvement and or reasonable relief of effects. The cure or relieve standard expands out to the following statement. As long as your care is curing, okay, or correcting the underlying condition, as long as it's improving function, or as long as it's helping to relieve the effects of the symptoms like pain, as long as it's doing any one or all of those, you have, reasonably so, you have medical necessity. Now, one of the beauties of citing to Dr. Art Croft, I call these the Croft ICAC treatment duration guidelines. One of the beauties of this is built in to the Croft ICAC treatment duration guidelines is a truism that it takes 2 to 24 months for ligaments to heal, okay, depending on severity. And that's why the standards are the way they are. If the standard of medical necessity was simply when the patient is out of pain, the care is no longer medically necessary, then this here, you know, then this would not have the weight that it has. But part of the bolstering of the Croft ICAC treatment duration guidelines is they take into account the fact that the spinal adjustment is actually helping to correct the underlying condition relating to ligaments, okay, which is all about the lining up of the ligament fibrils so that they line up more appropriately. And we're going to come back to that point. So my point in your letter is cite to guidelines, but even if you're outside of the guidelines doesn't mean the care is medically not medically necessary. This is just an indicator that it is, but if it's outside of the guidelines, you still have the governing standard of medical necessity to fall back on. And what I can share with you folks is that some of you are doing a very good job of documenting up your cases, but what you're not doing is you're not borrowing from the laws of medical necessity in the way you're communicating your care to the adjuster or to the attorney. Okay, and by the way, this letter is designed by default for unrepresented cases. All right. Lastly, it's very important that when you send your release letter, that you say what's attached. And I think you should go even further than that. I think you should send it by certified mail. And you'll notice that I mention here the correlation document showing the severity of injury based on the Cronk ICAC treatment duration guidelines. But I also think it's important for you to share the CRMA and have proof of receipt, as well as even the referral form for the CRMA. So when you requested a CRMA, include the referral form for why you requested it, as well as the CRMA report. Okay, and doctors all the time ask me, well, should I send the CRMA report or make sure that the adjuster has received that report? Absolutely. If you do that and you have proof that it's received, it's going to make it a lot easier for you to be working back and forth with the adjuster when it comes to payment time. Okay, so Dr. Cronk, did you want to jump in with any questions or comments there?
I think at this point, Keith, we'll get to like wrap up and have a Q&A.
Yep. Sure.
So go ahead. Why don't you go ahead and wrap up with whatever you want to wrap up with, and then we'll go to a Q&A.
Yep, and by the way, folks, for anybody who comes to one of our seminars, we are offering 3 months of training for any healthcare practice that brings 2 or more people to a seminar as a way of really building out the value of the time that you spend, the investment of time. So if you, we really want to make it worthwhile for you to travel and take a day off on Saturday. Because this is an opportunity for you to come and hear a session live and then get a rolling start into a really well-structured training program that basically extends out the value of the seminar over a course of 3 months. So that's available now with our seminars, and so take advantage of it. Make sure to check out the seminar page. But I love this last thought here of I like to conclude with another law of medical necessity, which is really a law of the human body. And this is a quote maybe you've heard before. It happens to come from Dr. Dan Murphy. And right now, what I want you guys to do, I want you to either write this down or I want you to just do it right now. But if you send an email, I've got a slide on this. If you send an email to Keith@pibackoffice.com, Keith@pibackoffice.com, you'll get an autoresponder with a link to the very article. And yeah, I strongly recommend you include the article in your documentation and presentation. Soft tissue healing occurs over a period of 12 months or more, very consistent with the Cronk ICAC treatment duration guidelines. Controlled motion, including the chiropractic adjustment, is the best approach to enhance the quality of ligament healing, especially in the remodeling phase. This is one of the truisms, and it's a law of the human body there in the beginning. It is one of the truisms that gets me most excited about what I do, because what I do is help providers who follow this get paid, and that's very satisfying to me. So send an email there. It's Keith@pibackoffice.com. In the subject line, just put anything. Send me notes if you want to. Be checking your spam or your junk, because sometimes these emails go into junk or spam. Send an email. It'll have a copy to the article as well as some notes from this presentation. And enjoy, certainly take advantage. Oh, and by the way, that email will include a link to the free sample PI release letter, as well as to the recording. So, Dr. Cronk, did you want to? Perfect.
Mm-hmm. No, I'll tell you what. I'll take it from here, Keith. One of the things I just wanted to stress, you know, Keith used an example today, and of course, What he's saying in the AMA guides is medical documentation. The rationale for medical documentation is allow the adjudicators and anyone else to determine financial benefits that the patient may have coming to them. That's all medical documentation is. And good providers, I mean, at Spinal Kinetics, our whole approach is early detection leads to better corrections, and patients that actually need that leads to benefit lessening. Providers who actually do fantastic work are the insurance company's best friend, right? So if you can take a condition, let's in Keith's example, he had a doctor who said, "Hey, look, I've got a rateable condition." Right? I just showed you the rateable conditions. There's only 3 rateable conditions, realistically. There's fractures, there's excessive motion, and there's disc herniation. So the doctor's saying, hey, look, I've got one of those 3 documented, and I've got now this information. I've got my Keith Pendleton UCC lien lined up. I'm calling the adjuster. I get it direct. It goes to a $30,000 settlement. Right, which means the $6,000 doctor bill got paid. It means the attorney got, if he's taking 33%, he got $9,900, and the patient got $15,100. That's what it means in a settlement process. Now, the only thing that it should excite to me, and I'm going to jump over from the medical side, is patients that actually come out of treatment that have no chronic pain, that have no activity of daily living loss, because that's the ideal scene for the patient. And doctors that can produce that will produce fantastically large clinics and fantastic results, and they should be paid. That's why we bring on the Keith Pendleton, not the Keith Pendletons, there's only one Keith Pendleton. That's why we bring on, because those doctors they should get paid. They deserve to get paid. Doctors that do fantastic work deserve to get paid. And so, you know, I love the fact, Keith, that, you know, and I know I'm gonna bring it up, but you know, you can look at these forms of doctors, and the thing is, it takes a while. I remember when Keith, the very first, gosh, this was probably 8 years ago, 7 years ago, I looked at the very first assignment form that we started using. I was like, okay, it took me a while to figure out the language that was in the assignment, but once I figured it out, I was like, my gosh, this is the foundational form that we're sending out, and this is all that's behind it? And that's really all you have to know. Because it is that simple. It really is that simple. So I want to go to Q&A, though, Keith. For those of you that are new to these programs and you're interested in doing spinal ligament testing, which I can't imagine, I'm a doctor that says doctors that don't know the status of the injury that the patient has, I have a problem with that. Injury patients today don't deserve that. They deserve the best. In my position, in my education, in my training, and everything that I talk about is injury patients have to go to the best doctors because they're at too high a risk for long-term chronic pain and long-term financial hardship that comes with that. So they have to get to the best doctors, and that starts with doctors that understand the condition that they're treating. So for those of you that want to ligament test, and you see the relevance of that, it's www.thespinalkinetics.com. I'm going to go to question and answers. For those of you that don't, that want further information from Keith, and I've got some questions on that. You can go to learn more about it. You can go to keithpendleton.com. So Keith, one of the questions that I have here is, Keith, you mentioned the use of certified mail to send for review. Can certified mail ensure that all contents of the mailing are shared with the reviewer, or is that letter combined with sending to the insurers? And so, in other words, what she's saying is, I believe, is that if you use certified mail to send to the reviewer, does that ensure that he got everything? And I think what she's saying is, hey, I could send it to the insurer, and then the insurer could send it out to the third party, or if I send it to, let's say I send it to Auto Injury Solutions, which is a major big reviewer, right? how do we know, or does that ensure that the reviewer actually got all the information? Well, what I can tell you right now, Shannon, what it does ensure is it does ensure that people were put on notice that they were given it, and if a reviewer is not given all of the pertinent medical information for a review, again, it's not an accurate view, and companies can get in trouble for that. But Keith, what would you say?
What I would say is it definitely puts the adjuster on notice that the provider has the basis for finding out that key documents were stripped out or omitted. It definitely does. But where it really comes into play is so it puts everybody on notice that if you have a modus operandi of not sharing all of the documentation with the reviewer, you are hereby on notice that we're likely to discover it. Okay, and it happens. It happens quite frequently. And let me give you an example. So we have the case where the reviewer doesn't even comment on the MRI report that you sent by certified mail. Well, you're able to respond now, when you see a review like that, you're able to respond with that either the reviewer did not receive it or chose to ignore it. You remove any possibility that you were wrongful in not providing it. Okay, you remove it and take it off the table. And I know for a fact, because I've spoken with reviewers, I know for a fact that when providers submit their documentation along these lines, I've had reviewers get review requests and turn them down. I'm not doing a review in this case.
Right, I've had that happen.
Yep, so folks, I'm going to share with you right now, is it foolproof sending it by certified mail? No, but through a combination of factors, definitely has the tendency to discourage the stripping of documentation from claims or withholding of documentation, and it definitely promotes and takes away. And some adjusters, their response to this is, if their modus operandi, which there are some out there, maybe a lot, there are some out there that do this, okay, that actively do this, unfortunately. And when you send it by certified mail with a well-structured cover message, it helps to take that away. It helps to diffuse any desire to do that. Okay, and then it can lead to discovery just by the example I just gave. Well, there's lots and lots of other examples of how you discover, if you have a basis for saying, well, we know we sent it to you, you received it, we have proof. So either it was withheld or the reviewer just simply decided, hey, I have no legal duty to respond to it. And both of those, either one, it doesn't matter which one it is, either one of those conclusions have a tendency to encourage adjusters to say, yeah, this review might not have been the best one in the world, right? And we have adjusters who push those reviews aside and say, especially when the adjuster knows that they're accountable to the doctor. Yeah, we have that combination of law and medicine can be very effective in, just like the doctor from Washington, eliminating reviews.
Okay, I got a good question here, and I'm gonna start to answer it, and then I'm gonna pass it off to you. It's how important is dynamic EMG in the documentation process for soft tissue injury? So, Doctor, EMG is a objective way to determine that there's a functional problem. You still want to have, so if we take a look at the case right here, there is severe ligament damage here. There's severe spinal instabilities here. Now, you could say, well, okay, if I did a range of motion test, could the range of motion be off? Well, maybe it would be, maybe it wouldn't be, right? So range of motion does not tell you what's going on intersegmentally, it just tells you what's going on globally. Now, if I take and I have these underlying severe derangement patterns, is my functional EMG, dynamic EMG, is that going to be abnormal? Sure, it's going to be abnormal. Now, you can't use it from the document or from a diagnosis side. All it tells you is you got an abnormal dynamic EMG. It doesn't tell you what's causing the abnormal dynamic EMG. That's where the injury analysis comes in. Now, where the dynamic EMG really shines is now each and every reevaluation time, you're reevaluating with a very, very, very specific piece of equipment that's showing functional improvement. So in the cure or relieve phase, and I need to show that I'm actually making improvement. If I'm going to treat the patient for 3 months, 6 months, I have to show that I'm making consistent improvement. Boy, that's where the dynamic EMG really comes into play, as do other pieces of equipment, but that's where it really comes into play. Keith, would you say, have anything to add to that? Or
the main point I would like to just actually broaden the question to and just share with everybody, anything that you can do to objectively or subjectively or both, preferably both, anything you can do to objectively and or subjectively, my preference would be that you're doing both, to show that the patient, that you are curing or correcting the underlying condition, that you're or you're improving some kind of functional deficit, or that you're relieving the symptoms of the injury. Anything that is a combination of anything that objectively and or subjectively, preferably both, that helps you do that is good. Everything that is good. Everything you do, you can do lots of it, you can do a little of it, but for goodness sakes, folks, communicate what the light is, the governing standard is, for even determining whether they have to pay on it or not. And that's what I find is so missing 99% of the time in reviews, and quite frankly, I don't see a lot of the healthcare providers pushing that issue in their communication. So I just wanted to broaden it a little bit.
Sure.
Cronk?
Keith, the next question I have, and possibly our last question, just to not take these doctors out any longer, but there's a question on, okay, how does your program work?
Mm-hmm.
They have a question on, like, how does your program work, and if they bring to, you know, how do they get involved with your program if they want to?
Okay, so folks, best thing to do, there's my phone number. I'm kind of old-fashioned, call me on my mobile phone. That's the best thing to do. And what I do with doctors is, I'm not going to rush it with you. We find a time that works for you, works for me, and I walk through what we're doing. But let me tell you just really briefly what we're doing. We have seminars that are awesome. Okay, they are amazing. They are among the best, if not the best, personal injury seminars in the nation when it comes to reimbursement and marketing. Among the best, if not the best. Okay. Secondly, I have an online training program that I can share with you about. Thirdly, PI Back Office is the first ever AR management group that follows my protocols. They utilize Dr. Cronk's protocols and documentation methodologies. They're a first ever AR management group that now handles account management cradle to grave, where they do it for you, and you basically treat the patient and just do the things that they ask you to do. And I have doctors that when they're liberated of the hassles of PI, it's like the first time, it's like the time that you adjusted the patient the first time, where there's such a relief of pain, the patient starts to laugh because it's such a release. And we have doctors that are making far more money than they were before, and not having to deal with the hassles of managing their personal injury cases. They have both. The cake, you have your cake and eat it too. That's PI Back Office, the done for you AR management service. I have some doctors that, no, I want to keep doing my own PI, making less money and dealing with the hassles of PI. Okay. That's you. I guess you enjoy that, right? There is also, we are coming out with a first ever software system, an injury payment and marketing system. It's going to be released in July, and it is automating processes that have never been automated before in personal injury. The whole payment protocol, the medical billing and documentation systems that are out there don't know what to do with PI. This is not a system. It does not try to replicate what Jim Mathis has done or Frank Liberti. what they've done is great. It's a piece of the puzzle. It's definitely an important piece of the puzzle. Ours does everything else, including the process for making sure that the payers are accountable to you, which is the name of the game in personal injury. That system, we're taking beta subscriptions. We're making beta subscriptions available right now to that system. And there's not going to come July that we're not going to be selling direct access to the system. So anybody who wants to leverage that system should become part of the beta program now. Lastly, we're even doing strategic partnerships with providers where we take a certain provider that's really looking to do a full court press and build out a significant PI footprint in their metropolitan or in their area. And we have a heavy duty strategic partnership program. So back to your question, Dr. Cronk, best thing to do is just give me a call. And then what I do is I interview, I find out where you're at, what your goals are and everything. And then have you lead me where you want to go, okay? And tailor what we do for you based on your goals, okay? And so I find the best thing to do is rather than say, hey, go to this website and read a whole bunch of junk, just give me a call. Okay.
Yep. Okay. Sounds good. And I've got your doctors. I've got Keith's phone number right there, 715-245-9735. And Keith, I tell you what, I very much so appreciate the program today. I appreciate you coming on board as always. And I'm sure you made the offer. You know, we'll look at doing something more in the future as far as on maybe an ongoing thing, but I very much so appreciate it. And doctors, if you haven't worked with Keith Pendleton before, call him. That's all I got to say. Just call him. Doctors, thank you very much for your time. And again, twice a month we have these programs. Sign on board, and we appreciate you. Have a good rest of the day.